Ready? Good. Good morning, everybody. I have that it's 10:03. We're going to go ahead and begin this morning. I am Matthew.
10. You said 10 or 3.
I have 10.
Oh, I thought you said 10.
I have 10. My name is Matthew Roepstorff. I'm a licensed attorney here in the state of Florida with the firm of Gray Robinson. I've been appointed as the special magistrate for today's hearing. This is essentially a code violation or an ordinance violation appeal stemming from a notice of violation that I believe was on June 13th, 2019, issued to Ms. Susan M. Hutt, a trespass warning from the Charlotte County Administration Building. Ms. Hutt filed her timely notice of appeal and has invoked the quasi-judicial appeals process for the ordinance. If everybody could go ahead, I see we have a court reporter here. Thank you. If everybody could state their name for the record, starting with the county.
Philip Fairman on behalf of Charlotte County.
Okay. Are you Ms. Hutt?
Susan Hutt.
Good morning. Yes, ma'am.
I'm
an administrative assistant today, but you'll say no.
Okay. Are you a licensed attorney at all?
No, I'm not.
He's a retired person,
Okay.
not ever a attorney. He's just organized
I'm
my papers.
managing the paper, we have
It's fine. As long as we proceed smoothly without interruption. I'll tell you this, if you had counsel here, it'd be different. But I'm only going to allow you to address these with arguments.
I'm prepared.
Perfect. And Madam Court Reporter, if you would state your name for the record.
My name is Sophia Blissett.
Okay.
Just let me check this.
Sure. I see we have a few people in the gallery today, which is fine. As long as we don't have any outbursts or interruptions or speaking out of turn, anything like that, we'll be fine. I don't mind recording or filming. I see one gentleman has, I'm assuming I'm being filmed with his cell phone camera. That's fine, as long as it's on silent, as long as there's no clicks or shutters or noises that are going to disrupt the hearing today. That's all fine. Are there any people who intend to testify as a witness out in the gallery today? I see none. I want to go over the format for today's hearing. Again, it is quasi-judicial. This is not actually a court of law. I'm not a judge. This is an appeals process from a code violation where I am a special magistrate. We're going to have a quasi-judicial hearing, which is a bit more relaxed than a formal court of law would be. We're going to conduct it in a very similar due process manner, where I'm going to allow both sides, if they wish, to make a very brief introductory statement, not entering any evidence, not talking about any of the evidence going to be entered, but just a brief statement of what you intend to show today and what your case is about. The burden is then on the county. We'll let the county present their case, call any witnesses they may have or they may like to present. Ms. Hutt, you'll have the opportunity to question and cross-examine those witnesses. Once the county is done with their case, Ms. Hutt, you'll have an opportunity to present your own witnesses. And the county, Mr. Fairman, will have an opportunity to question and cross-examine any witnesses that you provide. Once both sides are done presenting their evidence and their cases, I'll allow a very brief closing argument, and then I'll issue probably a written decision within the time period. I think I have 7 days after the conclusion of the hearing. We have a little more relaxed.
Is that calendar days or?
I believe it's calendar days.
Okay.
We have a little more relaxed rules of evidence than a normal court would or a court of law would. What I like to focus on when considering evidence is it relevant and is it reliable? Either side may feel free to object to any evidence or testimony that the other side brings in if they feel it's improper or not relevant or not reliable in this case. But again, there's no formal rules of evidence. I'll be the final arbiter of which evidence comes in, what's considered, what's not considered, in making my decision. Does anybody have any questions about the actual format for today's hearing or any questions?
I do. I prepared an opening statement, but my opening statement is a preview of some of my testimony, so.
That's fine.
Oh, okay.
That's fine. I just don't want to get too far into the weeds, repeating ourselves between the opening statement and then whatever you're going to introduce. we'll just keep it a brief preview, like you said, instead of getting too deep into the weeds on it. Any other questions? Mr. Chairman, if you want to go ahead and make a brief opening statement.
I don't have any questions, but I have two matters I wanted to bring
Sure.
to the magistrate's attention.
Sure.
I was notified that, our main witness, Deputy Randy Sterling, was gonna show up just as I was gonna tell before. I'll tell you that he wouldn't delay, so that's been solved. The other matter is, with respect to the, gentleman in the rear doing the video. Our facility rules prohibit that. However, for purposes of a record, I'm not going to object to that, but the only caveat to that is I would object to the gentleman using that video at a later time on social media, and I would object to the publication of my voice, image on any social media platforms. I just want to put them on notice of that. I don't want to be on YouTube, I don't want to be on Facebook or anything, but just for the purpose of assisting Ms. Hutt in a record, that's fine. I don't know why they need it if they have a court reporter. I think it's redundant, but I just wanted to put that objection on the record.
Sure, and won't cite it specifically, but I'll just say anybody in the gallery who wishes to make any audio or video recordings, it's upon you to accept any liability for what you do with that audio or video recording, and you accept any consequences of any publication or reproduction of what you do or improper use with that audio or video recording, just so everybody is on notice today and can govern themselves accordingly. Any other questions?
No?
Yeah, I want an objection to that.
An objection, his objection?
Yes.
That's noted.
Thank you.
Go ahead, Mr. Chairman.
Okay, I'll make a brief opening. To my left is Deputy Sterling with the Charlotte County Sheriff's Office. He works at, most of his work is at the Charlotte County Administration Building, where he's here to provide security for anyone who comes on the property, employees. On the date in question, he was working the front desk. Noticed Ms. Hutt walk through the main entrance, kind of a quick walk by. She had what, for lack of a better term, a body cam. I have a photograph to show you essentially what it was. Dangling around her neck, stopped her for a second as she's walking by. Said, "Are you videoing?" "Yes, I'm here to pick up records." So right away, alerted him, he told her, no video. She proceeded all the way down the hallway to the records department, where a fellow by the name of Mark Wintercorn was going to provide some public records to her that she requested. And right away, Deputy Sterling alerted him. He got on his phone, called up to the 5th floor where Ray Sandrock, County Administrator, worked. Said, "I'm going to need to talk to you about a trespass." Went up there with the form, signed the trespass. Ms. Hutt finishes her work at the Public Records Office, but while she was there, you're going to see some statements that she sent in her own handwriting, saying where Mr. Wintercorn specifically asked her not to record him. Nevertheless, she continued to record. Appears she may have turned the camera towards the door. I'm not certain about that, but she continued to record while he asked her to stop. She goes out the door. By now, Deputy Sterling is now on the 5th floor getting trespassed. Ms. Hutt has now left the front on the same path. Deputy Sterling was able to get her attention as she was engaged in a conversation with another individual. Issued her the trespass warning. Trespass warning was for recording in the building, in the hallways, and with in the presence of Mr. Wintercorn. So that is going to be our case, but I'm going to point out two things. I anticipate Ms. Hutt is going to tell you about the constitutionality of this, the constitutional right to record. I'm going to present the magistrate with a memorandum that we've prepared where your authority will be limited to two items. Was validly issued, and Really, that's essentially gonna be it. What was the trespass warning validly issued? And, did her conduct violate, did her conduct violate the rule to justify it, the issuance of the trespass warning? And was there authority to grant, to issue the trespass warning? Does Ray Sandrock have that authority? Obviously, yes. Jeff, the answer will be yes when this is over. Was it validly issued? Yes. Ms. Hutt made numerous admissions to, videoing in the building. We're gonna play two, videos. The first video is gonna be, appears to be Ms. Hutt, with her body cam, as Deputy Sterling is actually outside the building, issuing her the trespass. And you'll hear her, what will be remarkable is you're gonna hear her say, is this for violation of Rule 7, which is the video, rule that says you can't video, so you obviously know about it. Play a clip from Wink TV where it turns out that she was leaving the property. There happened by chance to be a Wink reporter there, and what probably happened, she explained the situation either that day or shortly thereafter. She's on the news giving an interview where she admits she knew she wasn't supposed to record. So that's going to be our case, and I would suggest when this is over, this should be a short hearing. I don't know if the magistrate's going to entertain constitutionality. I would suggest that there's no jurisdiction to do that, but when it's over, I think you'll find that the county has provided sufficient evidence beyond preponderance that the rule was violated. Mr. Sandrock had authority to issue the trespass, and the trespass should be upheld. Thank you.
Ms. Hutt, go ahead.
What I've prepared is not exactly what I thought I was supposed to prepare. I was issued a trespass warning. I don't know what he just said. I couldn't get the note down fast enough. He said that I asked something, but did not ask something, if something was something. I don't know what it was. However, I did not, did I ask, he said that I asked Deputy Sterling if it was a violation of Rule 7. That's not what I asked. And that would be on the video. I asked what the other one was. He circled two things. And he first said Rule 7, and then he said Rule 10. And, no, he said 10.
Ms. Hutt?
I know. So we did just figure out that it was Rule 9, and I will be presenting evidence, and I will be mentioning constitutionality, but I have a lot more to mention. I'm wrongfully accused of videoing. I did enter the building with a camera. I did enter with the intent to video. However, hours later when I got home, I had no recording on my camera, except of him writing me up in front of the building. I don't believe I can be convicted of pretending to video, thinking I was videoing, assuming I was videoing when I wasn't. But I can say under oath that I was surprised when I got home and had no video of the encounter in the building. I'm going to testify that I've been to the records department many times. After I got this body cam, I was getting ready to start a new project with a blog, and I got a press pass. I was wearing the press pass when I came into the building and spoke to Deputy Sterling. I didn't have a lot of time to spare. I didn't want to stand and argue with him about anything. That's why I headed straight to the records department. In fact, I may just say, since now we know that I didn't video, maybe you have to wait till I'm under oath to do that. Maybe we should just make a summary judgment ruling or something. Or, I think it would be better if I exposed the facts of what happened, and constitutionality is certainly one thing, but unequal treatment under the law is another. I had videoed in the records department on previous occasions. I only videoed my own transactions. You'll see that on a video here today. And, Mr. Michael Wintercorn is his name. Michael, had asked me the day that I was not really recording. He said he didn't want to be recorded, and so I did turn the camera away, and I asked him also, and if I had my video, it would be proven that I asked him, why did you allow me to video in the past but not today? And I believe that I'll have an explanation for why he did that, in my, testimony, or when I'm talking later, because he is, studying for his bar exam. He knows it's unconstitutional to say I can't film in his office. He knows what the law is and how the county is wrong. He's always been so professional and so helpful as a clerk in that office. We talk about families and so forth when I'm in there. And I believe that if he were here, he would tell the truth and be able to back me up. However, for quasi-judicial hearings, we can't subpoena witnesses. We don't even have a case number for this, because this is some kind of a fluky judicial process that's unknown to me. So since I couldn't subpoena him, I did send him and a retired security person from the security desk, Calvin Hodge and Michael Wintercorn. I sent them both registered mail return receipt things asking them to come. Mr. Hodge said, I don't know you, I don't know any of the people involved, I don't know anybody who walks through here, so I really couldn't be any help to you. Mr. Wintercorn didn't sign for his, apparently a mail clerk or someone signed for it. And so Mr. Wintercorn didn't answer, so I emailed him, and he still didn't answer. So, considering that there is no evidence, I don't think I've got anything else to say. Oh, and I will be defending the charges of violating Rule 9. I did not disrupt anyone. I did not harass anyone. I never behaved in an unsafe manner, and I didn't interfere with anybody's jobs. And I did not record. That's the biggest defense that I have is I did not record. So, what do you want to do?
We're having a hearing on it.
Okay.
I am going to consider constitutional arguments simply because I'm not entirely 100% positive what the legal standard is or what my jurisdiction, my authority is as special magistrate on constitutional issues. If it comes along in my research after hearing all the evidence and reviewing the case law that I think constitutional questions are outside of my jurisdiction, then obviously I will set aside those arguments and concentrate simply on the facts. But I want to make sure I at least hear the evidence in case I decide one way or the other, whether, in my opinion, I have that authority to decide such questions. So we'll just go ahead and cast the net wide and do that today.
I need to make a comment about that. I was told that constitutional arguments wouldn't be allowed. I have no case citations, but I certainly have objections on constitutionality. So.
Okay.
Okay. I wish I had my case citations.
Thank you. Mr. Chairman, your case.
So I move this call to Deputy Sheriff Randall. You want him there or?
There, he's fine where he is.
So do you mind me coming here because he's going to be turning away to go to China?
Oh, sure, is it easier for you?
Yes, it's
Okay,
easier.
yeah.
I appreciate it. Thank you
fine.
very much.
Would you state your name, please?
Randall Sterling,
And where are you employed?
Charlotte County Sheriff's Office.
And what is your position?
I am assigned to the Murdoch Administration Center.
And what are your duties at the Murdoch Administration Center?
Security, county meetings, just any incidents that arise at the complex.
Okay. Did you have an occasion on June 13th, 2019 at approximately 10:30 a.m. come in contact with someone you either knew or later learned to be Susan Hutt?
Yes.
You see that same person here today?
I do,
You pointed out, describe what she's wearing.
right here in the, blue and, is that palm tree shirt? My shirt.
I'd ask that the record reflect that the witness has identified Susan Hutt. Could you describe,
Okay.
I would like to state for the record that Rule 7 is an arbitrary rule apparently, and I will elaborate on that more in the closing argument.
Thank you.
I feel like my case is being destroyed, and let me see. So have you ruled on the video? I can't show that video.
I rule, I'm not going to consider it.
Okay. So I have a whole list of questions about that. And I may not be able to ask the other questions that I had. Let's see. When did you determine that you were going to trespass me, write the trespass order? At what point during the events did you decide that?
After I asked you to stop and you refused.
How did I refuse to stop?
You told me you were just gonna continue with your business to records. And you've done it before. And you kept walking.
Mm-hmm. So I can't question him about the oath. I can't question him about the oath. What else do I have here? I'd like to enter this receipt into evidence that I did have business in the records department.
no, sir.
Okay.
In the order.
Hutt's invoice for records request dated June 12th, 2019 is going to be admitted as number 5.
And it's signed, the receipt was issued at note on the bottom on the 13th, the day I was in the building. I would like to ask Deputy Sterling if he's ever seen this memorandum. I don't know if he has or not. Do you have this in your?
I've got a copy, yes.
Okay, show me this.
That's fine.
This is a memorandum, that's marked for internal use only. It was sent to the Board of County Commissioners and their assistants from Ray Sandrock and Kelly Shoemaker. And I would like to ask you, have you ever seen this before?
No.
Are you aware of, have you ever taken a class? I'll sit back down. Have you ever taken a workshop or a course, a training course, in April called Interacting with Citizen Journalists?
No.
It was a 4-hour course. Do you know other employees who have taken this course?
The members of that, Board of County Commissioners all, I believe, had to.
Are there 160 of those members?
I don't know.
Okay. I would like to enter this, can I enter this into evidence?
No, no.
Without objection, as number 6, it will be the memorandum.
I'll have more to say on that, I guess, in closing argument, since he doesn't know about it. I have other videos. I have a video of me in the records department on June 4th, when I was allowed to record. may we do that?
I would have the same objection. It's June 4th, it's not on the date.
I mean, that's public record, but
What could it, let me ask you, when did you start enforcing the rule when you were out there?
the facility rules were enacted, I don't know the exact date, it was a month or two back, I don't know exactly.
Could we show him, would you please look at the rules again?
What specifically?
I'd like for you to look at the bottom right-hand corner, I believe.
I need a better copy then, because
I
mine.
have a better copy.
So there's some.
I want that one back.
I need this one back, but I'll show it to you.
He gave me one.
Okay. Do you see the tiny writing at the bottom of both sides? V 5.6.19
I do,
on both sides? Do you know what that means?
I don't.
Would you suppose, if I suggested to you that it means that this is the version that was created on those dates, on that date? And this is the version that was created on that date?
I would object as it calls for speculation, he said he doesn't know.
Sustain.
Were you enforcing rules since May 6th? Enforcing this rule since May 6th?
I don't recall.
Did you-
That date.
Did you enforce the rule against other people in June?
Objection, again, other people was irrelevant.
Sustain.
Did you enforce the rule against Mr. Kesselring in June?
Objection, irrelevant.
Sustain.
Wow. What am I supposed to do here? Okay.
Get your clothes on.
I don't suppose I can show the video of a man and of two men in the Justice Center, where one was obscene with his language and nothing was done by the deputies in there. I guess I have to ask them. This is so arbitrary. I have no rights in this room.
Do you have any other questions for Mr. Sterling?
Oh, I do, but I can't ask them. I've got my hands tied.
Would you like to try to ask him any other questions?
Sure, let me go ahead and ask them all these questions. I'll get them on the record, and people can object, but at least I'll have it on the record. How about that? Okay. Describe what went through your head that helped you reach the decision to issue my trespass warning, after you've read your oath.
Yeah, the guy was asked to answer.
Sustain.
It was not answered. What were you thinking when you decided to violate your oath that you signed when you took your job?
Objection, asked and answered. Also, as far as the question of saying that he violated his oath is inflammatory.
Sustain. Let me rephrase then. Do you have any other questions for Deputy Sterling about the facts and circumstances of what took place on June 13th?
I'll tell you what my problem is, and this is probably something a lawyer would tell me never to do, but I have a huge problem. I did not record in the building. My camera was not recording. I went home, I had no video on my camera. How do I prove, I can't,
Ms. Hutt,
what?
there's,
How do I prove that?
Ms. Hutt, There's a procedure to everything. You're going to be allowed to make all those arguments to me.
Those are arguments, but it's not
Closing arguments.
evidence is my issue.
Exactly, they're arguments. And you're gonna be allowed to make all those arguments you want to me at the end of today's hearing, and I'm gonna listen to all of them.
And do they count?
Of course they can.
Okay, I
Of
didn't
course they
think
can.
arguments counted if you didn't have
Argument,
concrete evidence to.
do me a favor, just let me talk,
Okay.
okay? Let me talk. Argument is not evidence. What I'm looking for is the evidence in this case. When the evidence portion is done, you and Mr. Fairman are free to take the evidence that I've heard and craft whatever argument you like as it relates to that evidence. What I don't want is argument and evidence at the same time or to be conflated with one another. There's evidence as to what Mr. Sterling saw, did, heard, whatever. You can take whatever he testifies to at the end of today's hearing, and I will sit here and listen as long as I feel it's relevant, and as long as I feel they're legally permissible arguments. I will listen to them all day. And you can talk about the evidence all you want. But for right now, I'm not interested in commentary about the process, because it is what it is and I can't control that. I'm not interested in commentary about his testimony. I'm not interested in argument right now. What I want to hear is the evidence in this case. So if you have any questions related to the evidence in this case, I'm happy to hear.
Well, my
Okay.
problem is, my evidence is being barred by his objections
By my rulings,
and your rulings.
yes.
How is this fair?
How's what, Ms. Hutt? I've explained.
I-
Anything that took place not on June 13th, I'm not going to consider. You know what, I'm not going to consider the fact that you've admitted you filmed in this building prior to June 13th. I'm not going to consider that, because it's not relevant to what happened on June 13th. Even though you have admitted you violated the policy on other dates, I'm not going to consider it. I'm only concerned about what happened on June 13th, because that's the process we follow. Everybody is allowed a fair hearing on the day in question. So the fact that you've actually admitted you violated the policy before, I'm not even going to consider it against your violation alleged today. And I'm not even sure, I haven't even made my mind on whether I'm going to found you violated the policy on June 13th. So stop assuming that I've jumped to conclusions already. I want to hear the evidence.
How do I have evidence of something I didn't do?
Exactly, that's why they have to prove it.
And they can't.
Stop. That's why they have to prove it. And you can argue to me at the end of today's hearing whether or not they've proved it. I don't expect you to prove a negative. You're right, you can't do it. That's why the burden is always on the government to prove it. If you think they haven't proved it, you can argue that to me today.
Okay.
All right. Any other questions for Mr. Sterling?
I don't think so, no.
Do you have any cross-examination?
No, sir.
Okay. Sterling, you may sit down. Now, do you have any other witnesses you'd like to call or documents you'd like me to consider? Aside from the videos I already said I'm not gonna look at. I think I went through, I think I've got everything in your exhibit packet. All the paper documents. Are there any other paper documents you'd like me to look
Do
at?
you have the memorandum from,
Yes, ma'am.
Mr. Sandrock?
Was that dated May 1st?
Yes.
Yes, ma'am. I have that as number 6.
Do you mind going through which exhibits or what
Sure.
numbers now, just for my records? Trespass?
My number 1 is your press pass.
Okay,
My number 2 is your body camera pic off Amazon.
okay,
My number 3 is your trespass warning, the double-sided trespass warning and facility rules. Number 4 is the oath of office. Number 5 is the invoice from the records request.
Played one they did accept.
And number 6 is the memo dated May 1st, 2019.
great, okay, thank you, I appreciate that.
Yes, ma'am. Is there any other documents you'd like me to look at?
No, Your Honor.
What's this?
Those are videos, sir.
Okay, you can give it back to him, so I've said I'm not gonna consider it. Thank you, Doc.
Don't worry, the one outside, it's over there.
No, thank you.
So are there any other witnesses you'd like to call or evidence you'd like to submit? You can testify on your own behalf if you'd like to do that at this point. But I don't want you to argue, I just want you to testify as to what happened.
If I testify on my own behalf and I say that I did not record, or if I don't testify on my own behalf and I only argue it, am I gonna get in trouble if I testify?
I would,
Am I gonna get crucified by him?
If you testify, Mr. Fairman will have a chance to cross-examine. If you don't testify, I'm limited to what I've heard from Deputy Sterling and the paper exhibits that have been provided to him.
So then you can't consider that as evidence if I don't testify.
I can only consider what's been presented to me as evidence, either through testimony or the documents.
Well, I'm probably gonna do something stupid here, then I'll have to testify,
No.
I guess.
No.
If there's comments from the gallery, I'm gonna ask you to leave. That's your one warning. Thank you. It's your choice, and it's your choice alone, whether or not you'd like to testify on your own behalf. And you can tell me your side of the story. But I can't take it as argument. I can only take it as evidence.
So if I don't testify and tell you my story now, if I tell you my story on argument and it's the same story, you won't consider it if I just tell it to you at the end. But if I tell it to you now, you'll consider it.
I wish I could answer more directly to you, but I'm not your attorney. I'm not on anybody's side. I'm not on their side, I'm not on your side. So all I can tell you in very vague terms is that once all the evidence is closed and we move on to argument, I can only consider what's been received into evidence, and that is the testimony of Deputy Sterling, the videos that Mr. Fairman played, and the documents that you both have provided. That's the only evidence I have on the record to consider. Because there's a very nice court reporter making a record of everything that happens, I have to stay within that record.
Okay, then I guess I have to testify then.
It's your choice. You're not compelled either way.
Now, who's gonna question me?
You can just tell me what happened.
I can just tell you what happened,
Do
okay?
you object to a narrative?
No, narrative is fine, no objection.
And then he can cross-examine me.
Yes, ma'am. There doesn't need to be any questions. If you want to tell me what happened from the time you woke up to the time you went to bed on June 13th, I'll listen to it.
Oh, God, I don't even know. Yeah, at the risk of crucifying myself, I guess I will have to testify then. You want me to sit there?
No.
Oh, she does, she might want me to sit there. Okay.
Good. Go ahead. Tell me what happened.
What happened was I went into the building with the idea that I was going to record my transaction just on June 3rd, I believe it was. And I went in, you might have seen some lights flashing or whatever. I was pushing buttons, going down the hall, it was in the camera. I'm a bit technically challenged, obviously. Went into the records office, conducted my business, walked out of the building. As we've talked about before, I stopped and talked to the guy who collects petition signatures, he's a friend. And out came Deputy Sterling. I went on about my business that day after he wrote me up. I went home later that afternoon after running errands, because I don't do county stuff all my life, I've got a life. I got home, I don't remember if it was before or after dinner. I offloaded my camera, and there was nothing to offload, except the video that was shown of Deputy Sterling writing me up out in front of the building. And outside, it was my understanding of their rules and regulations that you can record outside the building. I did not know that I wasn't supposed to record that. So now I've probably crucified myself again by admitting that I did something that's wrong. And now I've discovered all kinds of things today. We've got a government that's going against us, teaching people.
We're drifting slowly into
Sorry.
that argument part.
I don't know, I think I've gotten my point in. I did not record that day. I cannot be convicted of thinking or intending to record. If I had recorded, the recording would have been on the internet, as a member. I thought also as a member of the press, I could interview and record. Good thing I didn't, but maybe it's a bad thing that I didn't. I'm probably in more trouble for not recording than I would have been if I did record.
Anything else you'd like me to consider?
I hope I should just be quiet right now. I think I should be.
Mr. Fairman, do you have any questions for Ms. Hutt?
Yes, it is.
Please proceed.
Ms. Hutt, so you came to the administration building on June 13th to pick up records, correct?
Correct.
And before you ever stepped foot on that property, you were aware of the facility rules that prohibited video recording in the building, isn't that correct?
May I answer that with,
With a yes or no, you either were aware of Rule 7 or you were not aware of Rule 7.
I was aware of Rule 7, however,
No. Your answer is a yes or no. You'll get a chance to
I will.
explain that later. I'll let you explain that. Okay. And Rule 7 was the rule that prohibited video recordings, correct?
correct,
And as you walked in, you were wearing that body camera that you produced a receipt for or a photograph that was introduced in evidence, correct?
yes, I was.
And as the deputy said, you walked in the main door, the front door. Deputy Sterling was at the desk, correct?
Yes,
And you walked right past him, waved or pressed past at him the one you showed us, correct? And didn't break stride, correct?
correct,
And deputy said to you, "Are you recording?" Do you recall that?
yes.
And you responded, correct? Did
I
you respond?
responded, but not the way he testified.
Okay. You continued in your belief as you
May
were.
I add to that?
No. As you were walking down the hallway, to the best of your knowledge, you believed that that camera was rolling from the moment you walked in the door to the time you showed up at the public records office.
I don't
correct?
recall when I thought I turned it on.
Okay, but you believed you had
I
turned it
believe-
on as you entered the building, correct, at some point?
I believe at some point I had turned it on.
Correct, while you were in the building?
I don't know.
Well, you believed as you were walking down the hallway, that camera was recording, correct?
I believed it, I thought so.
Okay. And you went down to the public records office, which is kind of in a different building. You have to walk through some doors, then either take the elevator or walk upstairs to Mr. Winterhorn's office, correct?
No.
No.
You walk through the doors, you take a left in building B, and the records department is on the left, they're
Okay.
upstairs.
That's
They
where-
used to be upstairs, they're not there now.
Okay. Correct.
I don't wanna give you false information.
No, I think you're right, yeah, I should know that since I work there.
I was thinking that, but I wasn't gonna
Okay.
say it.
Okay, but you walked down the hallway to Mr. Winterhorn's office to pick
Yes, I
up the
did.
records. Okay. And Mr. Winterhorn asked you not to record, correct?
After, of course, after I had been reading it for a few minutes, correct,
He asked you if you were recording and he asked you not to, correct?
correct.
And you said something to the effect, "I'll point the camera towards the door,"
I did, I
correct?
said, I'll turn the camera so you're not on view.
Okay. And then you went out the main door, correct? You walked down the hallway, past the security desk, and went to the main door where you saw, I believe it's Mr. McDuffie is the individual out front?
Out front, yes.
And you engaged him, spoke with him?
Yes, I also spoke to Alan Hodge on my way out.
Alvin is the security guard in
Who
front,
is the
no,
guard?
yes. And,
Nice man.
and as you were outside, you saw Deputy Sterling came, and that's when you were issued the trespass warning,
Correct.
correct? And that video that we saw today accurately depicted the interaction between you and Deputy Sterling, correct?
Correct.
Now, that same day, at the end, well, at the end of that video, you were pointing in the direction of the Wink TV car, correct?
Correct,
And you engaged the Wink TV person there, correct?
correct. She was in the car.
She was in the car, you told her about what had just happened, you'd been issued trespass warning, correct?
I don't know, remember what I told her. We agreed that I would contact her, she would contact me later.
And you made arrangements to do that, correct?
Correct.
And the video that we saw from Wink TV, that was from your recording, correct? There was nobody else, you and Deputy Sterling?
Oh, that portion of it, yes.
That was,
yes.
that was what you.
But with me sitting in the chair, that was, I did not record that.
Okay, I understand, that was an inartful question that I asked. The interaction between you and Deputy Sterling, that was a product of your camera that you were wearing that day, correct?
Correct. She chose the footage that she used.
I understand.
Okay.
The video of you being interviewed, that was their footage.
Correct.
And we know for a fact that Ray Sanders, you've dealt with him before, correct?
I've I've been in meetings that have been,
You don't deny the raised Sandrock County
no,
administrator?
not at all,
Okay, we can agree to that, correct?
yes.
Okay. I don't have any further questions for this witness.
This side, you have a chance to, what we call redirect or fill in the gaps or
Yeah.
further elaborate on anything that Mr. Fairman asked you that you didn't get a chance to.
Yes, I would like to say one thing in response to what I was just testifying for. When I came into the building and I was asked, if I was recording, because I am technically challenged and I don't even know what's going on here half the time. I said, I think so, is what I told him. He doesn't recall. I can't help it if he doesn't recall, but I know I said, I think so. And I truly thought I did. But I have no evidence that I did. You have no evidence I did. He has no evidence, he has no evidence. Nobody has ever seen it because it didn't happen. If I had had evidence, it would have been put up with the same video as him bringing me up for trespassing.
Any other testimony you'd like to consider?
I did not, yes, I did not, I was not aware that you could not record outside the building. News reporters do it all the time.
Do you have any other witnesses or any other documents you'd like to consider?
Not that I consider, no.
Are you resting your case?
I believe so, yes.
Then I'm going to give each side 5 minutes just to get their notes together. We're going to reconvene at 12:15. Mr. Fairman will do his opening argument first. And this is, closing. And this is by procedure, as normal. They're going to get to go first. You're going to go second, and they get one brief rebuttal because they have the burden of proof. So they get the last one. Okay?
With the exception of constitutional issues.
I'll hear them. You know,
I don't have any constitutional issues to argue right now.
No, that's fine. Yeah. You
I was
just
told
can-
by others that you couldn't do it.
Well, I'm telling you right now, both sides are going to have until, what I say, Thursday?
Yeah.
Gotta be Thursday until 5 to get me any cases or memos you'd like to consider on those issues. Okay? So 12:16 now. We're going to come back.
Reason the phone off is because I had 2 hours of silence. And then beyond.
I'm wondering if I heard you correctly and said you don't care what the Constitution says?
It is now time for closing arguments. I will hear from county first.
Thank you. The first thing I'd like to do is provide the memorandum that we've already prepared on the constitutionality issue. I am not going to argue this since I'm not going to stand up and argue every point. I'm sure the magistrate can review that. Other than point out the case of Smith versus Cummings.
Where do you get your authority from? The Constitution.
I provided this to the magistrate in other matters, and I would, for purposes of the constitutional issue, I would just point out that the test is really public officials, public places, matters of public interest, and in this case, Mr. Winterkorn, if nothing else, is not a public official. There is very thin law on what isn't a public official, but I would suggest to the magistrate that the test really is this an elected official, is this an appointed official? And if you're just a governmental employee like myself, like the clerk over at the driver's license bureau, that if you're doing ministerial duty, that doesn't elevate you to being a public official. So to the extent the magistrate finds that Ms. Hutt was recording, if not in the hallway, at least in Mr. Winterkorn's office, that no constitutional right applies to that. And there is no First Amendment right to record under those circumstances or in the hallway at the building. And I think our memo should lay that out.
That supersedes the U.S. Supreme Court.
As I indicated before, this is really a strict liability violation is the way we look at it. and the memorandum, there's two things for the magistrate to look at, so it holds over the trespass. Was the trespass warning issued by an authorized person? Clearly, there's no issue. The deputy has testified that Ray Sandrock, the county administrator, Ms. Hutt agrees that he's the county administrator. We all agree the ordinance authorized the county administrator to issue it.
No.
So that's the first prong. The second prong, really, you have to look at is the basis for the issuance of the trespass. What's the law for this issue? Were there procedures? Did something happen that violated the rule? And the question is, was Ms. Hutt doing videoing in? I come to say videotaping, but nobody has a videotape. You video, so I may say videotaping, but was she videoing at the time? We've heard her testimony that she wasn't. What I think we should look at is the evidence that she was, because if she was taking a video at the time she was in the building, then she's in violation of Rule 7, which justifies the issuance of the trespass by the authorized person, Ray Sandrock. So, she says, I was, well, let me back up. Let me start with the deputy and what she said. The deputy said, are you videoing? Her answer, yes. She says, I think so. Clearly was her intent. She walked in that building with the intent to video, thought she was videoing, and now we find out that she wasn't. The deputy said, I saw the green light on her video camera. That means she was videoing. So what we have is kind of a...
He knows this?
having to prove a negative that she wasn't. But the evidence is suggestive that she was, because it said she was, and the light was on, and what comes in today, and we have a Nixonian rosemary wood gap where evidence has disappeared. Just like the 13-minute gap in Watergate where tape is missing, now this is missing. However, the light was on, and she said she intended to video. What we have seen is what she wants us to see, and what we don't see is what she doesn't want us to see. It's just too convenient that all of a sudden this
The county won't produce stuff either.
Transpired from the time she walked down the hallway to the time she walks out and she's missing, but all of a sudden it's working again once she's outside on the front door. So I would suggest to you that it's not believable that she wasn't videoing, and that in fact she was. There's nobody is accusing Ms. Hutt of being a bad person, of consciously being an agitator. No, we're not saying that. She appears by all accounts to be a concerned citizen. She has the right to come to county commission meetings. We know that, but we cannot selectively enforce. Just like if there was she wanted to introduce a case with the objection. I said, okay, we can't say a bad person, you can't record, a good person, you can. If we see somebody operating a video camera or videoing in the building, they have to be trespassed. Deputy Stern said, try to tell her, give her a break, tell her to turn it off. You don't have a right to video. She just kept on going by. So it was a clear violation of the ordinance. Our burden is to prove by a preponderance of the evidence that the video and that the county administrator had the authority. We believe we've shown that by a preponderance. Now, if this were a criminal proceeding, would there be reasonable doubt? There might be, but this is strictly by a preponderance of the evidence. And if we believe that we have shown by the evidence So we have tilted those scales of justice just ever so slightly by a preponderance, at least in the county's favor. Did we prove it by fine to be within every reasonable bound? I don't think so. We've heard her testimony, but that's not what we have to prove. The standard is preponderance, and we believe the preponderance of the evidence is she was videoing, knew she was videoing, intended the video. By all accounts, the video portions of it survived, so that we believe that it's reasonable to conclude by preponderance of the evidence she was operating a video camera or videoing from her little test-mounted camera of the entire transaction, and the documents that we provided support that. So we would ask that the magistrate uphold the issuance of the trespass warning to Mrs. Hutt.
Ms. Hutt.
Quite a bit now. Deputy Sterling wrote a trespass warning against me without verifying evidence. He assumed that I was recording because I was wearing a body camera inside the building. I will have to go home and check now, because I'm still not an expert with this camera, and I have not used it since that day. I'm going to have to go home and check to see if I even have a green light on the camera. I don't believe there is a green light on my camera. And I'm assuming I can still do my constitutional things later. I did not record inside the Murdoch building on June 13th. I can't explain what happened or why. I can't explain why it turned on when I was outside, because obviously I didn't know what I was doing. I didn't discover it until I got home from the Murdoch building, as I testified. I do not believe justice would be served if I am convicted for thinking I recorded and convicted, and I haven't produced any evidence. I am not a liar. I have been under oath. I have never been known as a liar to anybody that I know. It was my intention to record. I don't believe I can be convicted for intending to do something. What if I had intended to steal something in the building and it turned up missing later? That doesn't mean I did it. Or what if I was accused of stealing it and somebody else did it and I was able to prove it later? I don't do things like that. I did not make this up. I did not broadcast to other people in the public after I discovered that I hadn't recorded. But had I recorded, I would have published the recording. Why would I only publish the recording of me while Deputy Sterling was writing me up? My intent was to show that I could film in the building if I had a press pass, which I did, and I thought that having a press pass would allow me to report on things going on with my government as a citizen. I wasn't sneaking into anybody's offices or restricted areas. I did not record in the Murdoch building on that date. I presented evidence today of a recording that I made in the records department. Well, or did I? I guess you did accept that. I don't know. The receipt that I was in there. I did not have any recording of being in there. As you know, and I testified, Michael Wintercord was aware that I was recording, and but he didn't ever check my camera to see if I was or not. And he chose not to come here to testify today, or the county barred him from coming. This is about, I presented other evidence that I didn't yet present.
Talk about it.
All right, I'll talk about it. I would have presented evidence to show that a gentleman named Gary Snow was in this building, in the hallways, using vulgar and loud language toward another citizen journalist in the presence.
I don't normally object during these things, but we're arguing stuff that's really not in evidence. I mean, it's not a vigorous objection, but I know that.
And just for expedience, Ms. Hutt, I mean, I'm not going to consider evidence that, we discussed. I'm not going to consider evidence that did not come in to the record. So it's really not proper to talk about things that did not.
I can say this probably. There are many examples in this county of people who have been videoed, who are videoing, who got charged with nothing, no trespass warning or anything, who were extremely disruptive in public with other citizens around, and nothing happened to them. I didn't know this before I didn't video. I learned this as I was researching for my defense today, and I'm learning that I can't even use my own defenses. If I had recorded, you would have seen the video on the internet with the other video that I took. What is, and this is not my final constitutional argument by any means, but what is important? Is the rule important, or is the legality and the constitutional important? What prevails in these courts? It should be the Constitution that prevails, not the local rules that our county imposes to try to restrict the public's free speech. Citizens do have a right to record police doing their jobs. As a member of the press and going in to speak to a public official and conduct business with them, I believe I have a right to record my business in the records office. There was nothing untoward going on. I might have asked him some procedural questions if I had gone in there, but my camera wasn't on. Deputy Sterling has a choice in his job, but his sworn oath, he is supposed to uphold the Constitution, and I'll elaborate on that more, rather than the county rule, which goes against the Constitution, which I will elaborate on in the future. I feel like I'm being called a liar. I'm not known as a liar. I certainly wouldn't go film something and then think I could come into a court of law and lie about it and say, oh, well, I didn't really film. Yeah, I thought I did. But the false police don't rule in this country. You can't say, oh, well, I think you were guilty. And I certainly am not Rosemary, what's her name, from Nixon's office who erased any tapes. And, you know, that accusation really infuriates me, and if I could take legal action, I felt so inclined I would really like to take legal action if I got somebody calling me Rosemary, what's her name? Because I know I'm telling the truth. I'll take a lie detector test if somebody wants me to do that. I don't know how to prove a negative otherwise. So if the court would like for me to do that, I'll be happy to do that. And I will have to just add to my constitutional rules in what I propose in front of you later.
Does that conclude your argument?
I guess so. Wait,
Mr.
wait,
Chair?
just a second.
Quickly, please.
Let me add just one thing. Yes. I don't believe that has met the burden of proof for the preponderance of the evidence. I don't believe that his evidence tips the scales, because I believe that I have tipped the scale the other direction with the sort of testimony that I did not record. What I would expect to have been done was to have the deputy, when he was writing me up, say, "Let me see your camera," and he would have seen that there was nothing on my camera.
Anything else?
He didn't do that.
Anything else?
I guess I can't call another witness, can I?
No.
Okay. I believe I have a witness sitting here beside me who would definitely know that he was present when I downloaded my camera, which I didn't think about calling him now, but he would be accused of being a liar too. So.
Okay, Mr. Perry.
I'm not going to repeat everything I said, but the deputy can't just see the camera. His testimony was he saw the green light, which is suggestive of recording. He doesn't need to see camera can download the video to confirm it's the green light in and of itself. It can take it recording. Other than that, I would just do the video myself.
It's either colorblind or something.
What's that, please? Could be. Okay, I'm gonna ask one question, and if you're not really prepared to answer today, you can include it in your memo on the 18th. Because it's part of our argument, I would like to hear a response to this. Number 7 of the Charlotte County Facility Rules says audio or videotaping anywhere inside of county buildings or conveyances, except during public meetings, is provided below or otherwise approved by county administrator. You can either answer now. I don't want to put anybody on the spot, so you can answer later in writing if you'd like to. I would like to have some kind of information on the definitions of audio or videotaping. If there's a definition section in the ordinance, you can point me to it. Or if you have a broad definition in your own words, what those terms mean, audio or videotaping, I'd like to hear.
Videotaping or video recording or both?
Exactly what the language of the ordinance says, audio or videotaping.
Okay.
So, I won't prolong today. If both sides can include that in their written materials by the 18th, just a definition of what they believe audio or videotaping means. And with that will conclude today's hearing. I will have a, with any issues, we're going to timeline. Thank you all.